Good afternoon. This is a meeting of the Discipline Subcommittee of the California Paraprofessional Program Working Group. I will begin by taking roll. Bashan?
Present.
Falmouth?
Here.
Kirkmaier?
Here.
Spiro?
Here.
All present. Thank you.
Great. It looks like we don't have any attendees, so no public comment. And I am going to kick things off by introducing Andrew Tuft. Andrew, have you spoken to the Discipline Subcommittee before?
I'm not sure. I have met with the group that's discussing the rules.
That's the regulation.
Regulation, thank you.
Yeah, so Andrew wears many important hats at the state bar, but the hat that he's wearing for our purposes today is that he runs the mandatory fee arbitration program. So we're going to hear a little bit about the program from Andrew. He can answer any questions you have. I have indicated that your general sentiment is that the MFA sort of recourse should be available to paraprofessionals and their clients. And so maybe Andrew, you can talk also a little bit about what changes would need to be made to make that happen.
Sure.
But let's start with brief introductions. Andrew, you know Linda and I. Kim, do you want to go ahead?
Hi, I'm Kimberly Kirkmaier. I'm currently the director of the Department of Consumer Affairs, and I don't know how much you know about DCA, but we have 37 different boards and bureaus under the department that license and regulate about 4 million professionals. Business.
Nice to meet you.
Nice to meet you.
Ira.
Hi, I'm Ira Spiro. I'm Dean of People's College of Law. That's the reason that's how I got appointed here. And I know your father. I think our terms overlapped on COPREC.
Great, nice to see you, Ira.
Julie.
Hi, Andrew. My name is Julie Felmuth. I'm retired now, or at least I'm trying to be retired, kind of unsuccessfully. For 33 years, I was the administrative director of the Center for Public Interest Law at the University of San Diego School of Law. And we monitored about anywhere from 20 to 50 different state agencies that regulate business professions and trades, including the state bar and including many of the agencies within Kim's Department of Consumer Affairs.
Great.
All right, and Sharon.
Hi, Andrew. I am Sharon Bashan. I come from the legal aid sector. I'm director at One Justice. We are a statewide support center for all of the legal aid organizations throughout California. And I apologize that my webcam has not been working recently.
No worries. Nice to meet you.
And I see Justice Petru's box on him.
Yes.
Okay. All right.
I'm here. So hi, Andrew. So I chair the working group, and I'm not a member of this subcommittee, but I try to attend as many of the subcommittee meetings as possible to kind of keep my finger on the pulse and hopefully help things move forward. I sat on the Court of Appeal in San Francisco. Before that was a trial court judge. Before that was a federal prosecutor and in private practice. Nice to meet you and happy to have you.
Thank you. Nice to meet you as well. And thank you all for your warm introductions.
So go ahead, Andrew. You want to give us a little overview? I know you sent me an infographic that I did not share with the group. I thought maybe we could put that up, or however you want to proceed with just giving a high-level overview.
No problem. I could absolutely share the infographic. It would just take me a minute to grab it. Let me just give you a high-level overview quickly. And it's not an in-depth description. I'm happy to answer any questions. And after I briefly describe the program, I can grab that infographic and maybe they'll be informative for the group. Thank you all for your very kind and warm introductions of yourselves. As Leah said, my name's Andrew Tuft. I'm the supervising attorney in the Office of Professional Competence. My personal background is in legal ethics and the law of lawyering, but as Leah mentioned, our office manages a handful of programs, and one of them is the mandatory fee arbitration program, which I'm happy to speak with you about today. And as some of you might be aware, the mandatory fee arbitration program is authorized under the Mandatory Fee Arbitration Act, which is codified in the Business and Professions Code at sections 6200 to 6202. And the purpose of the program is to provide an informal, low-cost process to resolve fee disputes between attorneys and their clients. And the program's designed to ensure that fee arbitration is made available statewide, and the vast majority of arbitration cases are heard at the local program level. And the statute authorizes the State Bar to approve local bar association programs by submitting rules of procedure to the State Bar. And the State Bar is to review them to make sure that they are in accordance with the law and the rules. And once authorized, the program is, the local program's up and running. If a local program is in existence, they have original jurisdiction for any fee dispute that might arise in their locality. And currently there are 32 local programs. Unfortunately, every couple of years we lose a program. So we're trying to keep most of the programs up and running to the best we can, but they're really dictated at the local level as to whether or not a bar association is going to have and operate a program. If there is no program at the local level, or if the client or the attorney can credibly claim that they would not receive a fair hearing at the local level, then the dispute would come to the State Bar. And the State Bar has, I think we have nearly over 400 volunteer appointed arbitrators, and we would manage the program and try to appoint a volunteer arbitrator to hear the dispute that can't be heard at the local level. The annual caseload for State Bar handled cases is approximately, I would say, about 55 cases a year. It can go up and down depending on the year, and honestly, depending on the economy. We can see it's all anecdotal, but depending on how the economy is doing, we might see an uptick in these type of claims. The last time we surveyed local county programs to see how many cases they handled, I believe it was 2018, and they reported in total the local county programs handled about 970 cases that year. So in addition to handling the arbitration hearings, the State Bar program also has an enforcement caseload, and that's also provided in statute. And how that works is once a arbitration award has become final and binding, if the respondent attorney has not paid the award, the client can request assistance from the State Bar's mandatory fee arbitration program to open an enforcement case. And on average, we typically get approximately 23 enforcement cases each year, going back over the last 3 or 4 years or so. It's been on average about 23 cases. And that's handled exclusively by State Bar staff. And typically a staff member will reach out to the respondent attorney, and hypothetically, let's say the final and binding award is for $8,000. The attorney hasn't paid it. We'll ask the attorney, can you pay it in full? They may not be able to, so we would try to work with them and the client to agree to a payment plan. If they agree to that, then State Bar staff will monitor the payment plan on a monthly basis, or however they agree to pay the amount that's owed. And so sometimes that can take several years to close these enforcement cases. But if working with the respondent attorney fails, or they're non-responsive, then staff can draft a motion with State Bar Court to move the court to place the respondent attorney on involuntary inactive status. The motion's filed under the name of the presiding arbitrator, and the Board of Trustees each year does appoint a presiding arbitrator and 2 assistant presiding arbitrators, and those individuals are very helpful in administering the State Bar program. And once that motion is approved by the presiding arbitrator, a motion's filed in State Bar Court. The attorney has due process and has received notice. They can object, but if they don't, if they're non-responsive, they might not respond to that filing either. And the attorney, in some instances, could be placed on involuntary inactive status, only to be returned to active status if and when they pay the amount that's owed. And in a nutshell, that's the mandatory fee arbitration program. As Leah mentioned, I do have an infographic, and I will track that down very quickly. And in the meantime, while I'm looking for that, if anyone has any questions, I'm happy to answer them. I should also say, if you wanted to add paraprofessionals to this program, I think it would require a legislative change because the program is authorized by legislation. But I don't think it would be very difficult. I can't speak for legislative staff. I'm not a legislative staff person, but it's my understanding that if we were to be able to proceed in that manner, just quickly looking at the statute, it shouldn't be too difficult to insert paraprofessionals along with attorneys. And then, of course, we would have to revise the rules of procedure at the state bar level, and we would reach out to local programs to inform them of the change and encourage them to similarly update their rules of procedure. And they might be interested in that because it could, there are filing fees associated with these actions, and there might be some incentive at the local level to be able to process these types of disputes as well.
Andrew, if an arbitrator awards fees against an attorney to a client, is that considered discipline?
No, it is not discipline. That is an important distinction. I don't know the exact history of when or precisely why this program was created, but I do think just hearing stories from people in the ethics community, I think the program is helpful to both alleviate the discipline system of complaints that might be over fees that get lodged with chief trial counsel, as well as the trial court to ease the burden on trial courts from hearing these disputes, which might run up against malpractice claims as well. But the statute is clear. It's only to resolve disputes over fees and costs. It cannot resolve issues about attorney misconduct or malpractice. And
so
I hope that answers your question.
So if it does, thank you. So a fee award would not appear on the State Bar's website in the attorney's profile?
I don't believe so. Now, I don't think, no, I don't. No, I'm actually confident about that.
Yeah,
It would not. So what happens with respect to discipline, though, is before you file a motion for involuntary inactive status, there's a warning letter that goes out. Hey, you have not been responsive. We're going to add an administrative penalty. And if you don't pay the administrative penalty, that does get attached to your licensing fee. And so there are these monetary penalties, but I don't think that they are considered discipline for the purposes of what you're asking about.
Andrew, that penalty you're talking about, that's levied if they don't pay, or the administrative penalty. Okay.
Yeah, that's added on top of what they owe, and interest accrues as well, as provided under the statute. So it can get expensive for an attorney not to be responsive to a final and binding arbitration award.
How often does that happen? Does your office have any stats on how often they don't pay and they accrue these fees?
Well, as I said, we have about 23, we receive about 23 enforcement cases a year. I'm only hesitating because I'm not sure, like, of the 23, are there 10 to 9, 8 or 9 that once they hear from us, they go, oh, shoot, yes, let me pay this and get the state bar off my back. We have about, I want to say 38 open cases right now. And most of them are in a payment plan. There's a handful of folks who have just come in and have not yet been responsive. So like anything in life, there's a wide variety of experiences when you start dealing with these cases.
But these are very small numbers. Is it that people are just not eligible for this program? Because 38 is a small, like if you think about all the attorneys out there, these are not large numbers at all.
Correct. So we don't really know how many are resolved in so that if the dispute is resolved in favor of the attorney, or it's resolved in favor of the client, and then of the disputes that are resolved in favor of the client, how many are not paid by the attorney, and then how many of those does the client take the initiative to file an enforcement action with the state bar to seek assistance to compel the attorney to pay.
And Andrew, are the local programs required to submit data to the state bar annually? I don't remember this saying like
they're not required to.
Okay, so we really don't have a sense, Sharon, of the scale, which is probably problematic, or to me, it would be nice to have some statewide data.
Yeah, no, thanks for clarifying that. That's exactly what I was trying to figure out.
Can I ask a question? The motions to enforce fee arbitration, that's done even for the cases that are handled locally?
That's correct.
That your office files those. Okay.
That's correct.
Right.
Maybe I missed this, but if a lawyer doesn't pay and there's an enforcement action, can that enforcement action result in discipline?
No, discipline is a separate track. There could absolutely be discipline associated with the underlying case, but fee arbitration, the motion for involuntary inactive status is for failure to pay the final and binding arbitration award. So it's somewhat confusing because there is you're being disciplined, I viewed as penalized by being placed on involuntary inactive status. But what you're being placed on involuntary inactive status for is failure to pay. You could have acted ethically in your representation of the lawyer, of the client in the underlying matter, had a credible or reasonable dispute over fees and costs. The lawyer loses and then either drags his or her feet, fails to communicate, whatever is motivating the lawyer not to pay the final and binding award, gets them into the enforcement realm, enforcement of the fee arbitration award realm, and the result, the hammer that the state bar has to compel payment is being placed on involuntary inactive status.
Andrew, is that involuntary and inactive status, is that placed on their record though?
Yes.
Yeah.
Yes. Yeah. So you would go to on the state bar's website on their profile. Yeah, they would be listed as involuntarily inactive.
Andrew, I wrote down here that in 2018, the local level handled 970 cases. Is that right?
That's approximately correct. Yeah.
And do you have any more updated statistics than that?
Not that I could find.
Okay, and I have a stupid question. I assume that because it's called mandatory fee arbitration, if the client requests it, the attorney must participate, right?
Yeah, that's an important point. Thank you for raising it. I did not discuss that. It is called mandatory fee arbitration for the exact reason you identified. If the client requests it, the lawyer is compelled to go. If the lawyer requests it, the client can choose to go or not to go. And also under the statute in that regard, before initiating a claim to recover past due fees, a lawyer must give the client notice of their right to go to mandatory fee arbitration. And the client has 30 days to respond to that notice. If the client does not respond within 30 days, they've waived their right to non-binding mandatory fee arbitration, and then the lawyer can initiate a lawsuit against the client to collect those fees.
If the lawyer, if there's an arbitration over what the lawyer says are past due fees, and the lawyer wins, does that become an enforceable judgment in the Superior Court? A judgment
Against the
enforceable in
client?
the Superior Court, yeah, against the client.
Yes, yes, it can. And vice versa.
Oh,
So Andrew, what if a complaint comes in and the individual has a fee dispute and they want to do the mandatory arbitration process, but they also have a case that says, you know, this individual was dishonest with me or did, you know, something unethical. Does it bifurcate and split into two paths?
Yes.
Okay.
Yeah, they're not precluded. The tricky part is if they have a malpractice claim. If you file a malpractice claim against the lawyer and you're including the amount you've paid the lawyer, that waives the client's right to mandatory fee arbitration. But there was a recent revision to the statute of limitations for filing a malpractice claim. I think it was enacted January 1st of 2020. And so I think that's CCP code 340.16, and it tolls the ability to bring a malpractice claim or the requirement to bring a malpractice claim if there's a mandatory fee arbitration case pending. So it eases the burden on the client in terms of choosing which to go first. They could try to resolve their fee dispute through mandatory fee arbitration first, protecting and preserving the right to later file a claim for malpractice once the mandatory fee arbitration hearing is over.
I thought you were asking a slightly different question, Kim, and I don't think you were, but you triggered this question for me. If a complaint comes into OCTC and it is a fee dispute plus something else, this attorney won't return my file, something simple like that, will OCTC then address the fee dispute because there's another sort of hook into the case? Or would they say, okay, we can only address your client file issue. If you want to deal with your fee dispute, you've got to go over to mandatory fee arbitration?
I truly don't know how
Okay.
OCTC handles that. My sense is it's the latter example you gave. What is common is complaints will come into OCTC and it's just a fee dispute, and they will close the case and refer the client to mandatory fee arbitration.
Yeah.
But my sense is if there's a credible claim for discipline, I don't think OCTC would let that go. And my sense is they would, I think someone used the term bifurcate. They would. So I'm very confident State Bar Court does not resolve the fee dispute, but it would take the failure to return the files in their example, Leah, and yeah, they would probably, I would hope, I don't know this, but I would hope that they would refer them to mandatory fee arbitration to resolve the fee dispute.
Okay.
But I don't, that's just my sense. I truly don't know if that's the precise answer.
You might have already answered this question, but if a client requests mandatory fee arbitration and the attorney refuses, then what happens?
So the case will go forward, even if the attorney fails to show up. So there are procedural steps with any case. The request comes in, the request is filed on the respondent, typically the attorney. The attorney has 30 days to submit a reply. If the reply doesn't come in within 30 days, we have a relatively styled form letter, which is, no replies come in. The case is proceeding. We will now seek to find volunteer arbitrators to appoint to this case. And the case will continue to proceed. And if, again, non-responsive, the attorney never shows up, the arbitration award, if it's well written, will identify that the attorney was provided notice, failed to appear, notwithstanding his non-appearance. This is the finding of the arbitrators in this matter.
And if an award is returned against an attorney, does he or she have any appeal rights within your program?
So not within the program. Also another excellent question. It's within the statutory scheme. You have 30 days either party has 30 days. Even if you win and you don't think you won enough, you can seek trial de novo with the Superior Court.
Hmm.
And then failure to do that result. So it's non-binding mandatory fee arbitration. The parties can agree to have it be binding at the outset. Both parties have to stipulate. If they don't, and most don't, but some do, but the majority it proceeds as non-binding. The award comes in, and let's just say hypothetically, yeah, the arbitrator says client overpaid by $37,000. Lawyer, you need to return these funds. Lawyer's obviously disappointed or unhappy. Under the statute, they can appeal to Superior Court to have it heard trial de novo.
Hmm.
Failure to do so after 30 days waives their right to trial de novo, and the award becomes binding.
Now, I'm assuming that the attorneys are not represented by attorneys in this process.
Some are. Both. It's not super common, but it happens. Yes, both clients and lawyers can be represented by counsel.
Just to be sure, they can, even a party who agrees to the arbitration can still appeal if they want.
Yeah, if you're disappointed, I think I should have been awarded more. I'm not sure it happens. I'm not sure it's common, but as I mean, I could double check the statute. I don't think it's limited to the losing party. It's just someone who's dissatisfied.
No, I don't mean that, but
Oh, I'm sorry.
like, I'm thinking of the small claims court where if the plaintiff, well, I don't remember, but it occurred to me that if somebody chooses to be in this arbitration, they might not have a right to appeal, but if they're involuntary put into it, like the lawyer can be, they would have a right to appeal. But if that's not true, both sides have a right to appeal, even if they agreed to it.
That's my understanding. Yeah.
If a client gets that $37,000 award that you spoke of just a minute ago, and the attorney is just like in the wind, gone, there's not ever any, that person has disappeared off the face of the earth. Can this ever turn into a client security fund claim?
Yeah, I think so. I think that they can seek to recoup that. There are, my only hesitation is I'm not familiar with the qualifications for the precise qualifications, and Leah might know, for clients who can avail themselves of a client security fund. So it might be limited to requiring that discipline also be involved.
Yeah, I've never, Linda, maybe she stepped away, but she'll be the real expert, but I don't think so.
But it's
I
not
don't think
part
so
of,
either.
it's not part of the mandatory fee arbitration
Okay.
program. It's just if there was some component that would otherwise avail themselves of, they're not precluded from going to CSF if they would otherwise be available for it.
And CSF is limited to a determination of attorney equivalent of theft or an act equivalent of theft. So if there were a finding in the arbitration that for some reason that the attorney kept funds that they hadn't earned, so failure to return unearned funds is a basis for a client security fund claim.
But
So
Linda,
that's
doesn't there have to be discipline, or the attorney has died, or there's
that's
very
true.
limited exceptions for those situations where there doesn't need to be discipline, and I've never seen a mandatory fee arbitration award being one of those.
Yeah, I don't think it's like.
No, that's true. That's not. You're right. So there would have to be a discipline related to it.
So are you all continuing to have the sentiment that you want this available sort of in the same format as it is for on the attorney side?
Yeah, I am.
I am.
I have a question here. I'm sorry. There's a question about David or Andrew. Does it occur to you that there might be any reason not to have this system apply to this newly licensed, I'm sorry, to the paraprofessionals we're talking about who might get licensed sometime next year or the year after?
No, I mean, the only thing I could think of, and this might be above my pay grade and outside your scope, would be one of staffing. I'm not sure, what the increase of caseload might result from it. That's not a reason not to do it. That's just, something I'm thinking about. Another thing I was thinking about when I knew I was going to speak with you all is under the state bar rules, if a dispute is under $1,000, the assistant presiding arbitrator can hear, and let me even take another step back. Under the state bar rules, if the dispute is $15,000 or less, the case is heard by a sole arbitrator. And if the dispute is for $15,001 or more, it's heard by a panel of 3 arbitrators. If the dispute is less than $1,000, it's heard by an assistant presiding arbitrator. It can just be assigned relatively quickly to the assistant presiding arbitrator. And I wonder, this isn't something for you all to think about, but I wonder if some of those thresholds could be adjusted within the program to ease some of the administration of the program. So a dispute under $5,000, could that maybe be heard by one of the 2 assistant presiding arbitrators? That might ease the administration of these cases at the state bar level. But that's not something I really have the answer for right here, and it's not something I would expect you all to chew on in the moment right now either. But that is something that's addressed by rules of procedure, not within the statute. And I think that could be something to consider to help ease the efficiency of the administration of some of these claims.
That's a great suggestion, Andrew. Do you think if we were going to go in to amend the rules to incorporate or encompass paraprofessionals, that would be a good time to make that change on the attorney side as well? So that
yeah, I mean, we could talk about that. I haven't given much thought to it about the attorney side.
Mm-hmm.
As I say this out loud, I'm not sure why there would need to be a difference. So just something to think about, and I apologize for not having a more well-formulated thought with respect to that. But it's an easy way to resolve, not an easy way. It's a system that exists both at the local level and at the state bar to hear some of these disputes, which could arguably certainly benefits the clients. I think which underutilized could benefit paraprofessionals and attorneys to have this low-cost administrative hearing, resolve these disputes so people don't have to wade through court system or have them misfiled with the discipline system. So I like the program. I of course would advocate for it, and I think it could be easily and quickly applied to paraprofessionals.
You mentioned that these local bar associations adopt rules and apply for approval by the state bar for their MFA programs. Do they actually go hire professional arbitrators or use some of their own members, or what do they do? Yeah,
so I'll just speak to the state bar program. We have a training, an arbitrator training, and you have to sit through the training, where we have seasoned arbitrators explain the process, the procedure, the rules, and then there's an application. And once you've taken those 2 steps, you're presented to the Board of Trustees. The Board of Trustees approves you to be a volunteer arbitrator. those folks fill the roster for the state bar to assign to a case. And I don't know precisely what they do at the local level, but I think it's very similar. So they approve and appoint them through their local bar association, whatever their reporting and oversight structure might be. They might be slightly different depending on the bar association. And then once approved, those arbitrators are able to hear a case pursuant to their rules.
And I assume these arbitrators are paid?
There is a rule. So there's a different school of thought between arbitrators. Many think they should be provided as a free service. And all rules have at least a 4-hour minimum. So if any hearing is less than 4 hours, there's no compensation to the arbitrator. If the hearing goes beyond 4 hours, upon consent of both parties, the arbitrator can be paid. And at the state bar level, it's $150 an hour per arbitrator to be shared equally amongst the parties.
And they both have to agree to it. So why would they ever agree? Oh, because they want to go more than 4 hours.
Yeah, they think it's a difficult case. And the lawyer or the arbitrator who's volunteering their time, they can say, I've read your papers, your written submissions. This could take a day, maybe 2 days. Are you willing to consent to compensate me or the panel of 3 of us for $150 an hour for every hour that exceeds beyond 4 to be shared, to be divided equally amongst the 2 parties?
And
Andrew, does the state, I'm sorry, go ahead. Go ahead, Julie.
let me just one more. I assume there are conflict of interest rules so that I can't arbitrate the hearing of my law school roommate.
Absolutely. So under the rules of procedure, every party has a preemptory challenge, can disqualify an arbitrator for no reason. They can just say it and kick that person off. The next time they want to remove an arbitrator, they have to state their reasons why. And there's rules of procedure that would go to the presiding arbitrator to resolve that question if the arbitrator who's being requested to disqualify him or herself disagrees. But before taking any case, the staff will share the names of the parties with the arbitrator they're seeking to appoint to the case. That arbitrator, and there's an arbitration advisory which provides guidance to arbitrators on this very question. That arbitrator would check those names, hopefully against their internal conflicts check system, or might know them personally off the top of their head. If there's any association with either of those 2 parties, they will recuse themselves. If not, they will respond to the administrative staff and say, there's no conflict here. I have no relationship with either of these parties.
Thank you.
I was just going to ask, in terms of training arbitrators at the local, for the local programs, does the state bar provide training?
We can. The state bar has its own outline and training program. And we ask seasoned volunteers to put on those trainings. And sometimes we are requested by local programs. Hey, can you put a training program on for us here in San Gabriel Valley? And we can do that. We will reach out to volunteer arbitrators to see if they're available to do it, but we don't have to. It's much like ethics training. Sometimes in my office, CLE training, sometimes my office will get a request for an ethics speaker, but other times the trainings can be conducted at the local level for these arbitrators. There's no one way to do it. There's no, that's not a regulated aspect of the program in terms of who does the training and the approving.
But the content of the training is standard?
Yeah, I would say so. There used to be a committee on mandatory fee arbitration, and that was populated by folks who serve on local county programs. And so that committee generated a lot of the training materials. And so those training materials are readily available at all 32 currently existing local programs. So I think the training, I can't say for certain, but I'm fairly confident most of the training is fairly uniform.
Okay, thanks.
And when not, people come to us for resources all the time, and we're happy to share our training materials with anyone who would like to use them.
All right, unless anybody else has questions for Andrew, can let him go. Thank you. Andrew's actually on vacation today to spend the day with his kids. I thought in your suit and tie. So thank you so much for joining us.
Thank you.
Not a problem. Not a problem.
I hope you have
Pleasure.
shorts on.
It's my fancy jeans. Fancy jeans.
Okay.
It was a pleasure to be with you guys. Good luck with the rest of developing your program. If you have any other questions, Linda or Leah can always reach out to me. I can get information for you.
Thank you.
Thanks, Andrew.
All right, take care.
Bye-bye.
Bye.
All right. So I think we have just a couple of cleanup items from last time. I hope I have this right. I got some more information on these admonishments, which are not considered discipline. So the State Bar Court can issue an admonishment if the subject matter of the pending discipline does not involve a client security fund matter or a serious offense, and the admonishment is public, but only upon request. So it does not go on the attorney profile. It's very interesting.
Is it issued after an NDC though, Leah? I think that,
The NDC is on the profile, but not the admonishment.
and it just hangs out there.
I guess so.
Okay.
So I'm not thinking this is, I think we want to put NA here. I'm not thinking you want to have admonishments in your system, but let me know if you do. It's hard to understand given that it's not discipline either. I guess it's a way of once something gets to the State Bar Court, if they don't want to dismiss the case. And then there is something that if within 2 years of the date of the admonishment, the attorney does something else, then they can bring the admonishment back.
I would say NA for us for now.
Julie, Ira, Sharon, is that okay with you all?
And go through this again. The admonishment is not discipline, does not appear on the State Bar, on the lawyer's State Bar profile. It is in the State Bar's records. Do you know when it disappears from the State Bar's records, if ever?
It does not. The State Bar only just recently began to expunge. It didn't even begin, actually. It did. Complaints over 5 years old where no action have been taken have been kind of archived. They haven't even been destroyed. So the State Bar is not destroying discipline records.
And these are done only, admonishments are done only after a notice of charges in DC is filed?
Yes, that's my understanding. The court is resolving the matter by an admonishment. If the person who's the subject matter of a pending disciplinary proceeding, so it's.
Well, does anybody think we have something that takes the place of this, or that this is not needed? In other words, when I say this, something that's very, something that has these, it's not much of a punishment and really isn't a punishment technically, but that the hearing officer can use for a minor charge that they think is valid.
I think this is not needed. If the hearing officer determines that there was no violation, the paraprofessional didn't do anything wrong, they'll just dismiss the case, dismiss the complaint. And that won't become public as far as I know. We still have a warning letter, I think. And if there has been a violation, we have potentially this citation and fine system. So I think having this admonition or admonishment or whatever it is not necessary.
And we also have reprovals, right? There's a private reproval, which would be private, or a public reproval.
Remember,
Yeah, I think, yeah, we said NA to the private reprovals.
Oh, right, sorry, we have a public.
According to this
reproval.
chart.
Mhm.
But we do have public reprovals that can be issued before or after a NDC is filed, and they go on the website for 10 years.
going farther up, there was something else you all just referred to that we have.
The warning letter?
Yeah, the warning letter. Okay, so that's something, and that can be issued by the judge, the hearing officer, or no?
No,
think
it's upstream, OCT.
Yeah, that's what I thought.
Can you give me an example in the attorney scheme of a situation or a scenario where the attorney would get an admonishment versus something more?
I'm just reading the rules, and I can send you all this link as well. Let me go down here. 5.126. Sorry, I scrolled up to look at something else. So it's permissible when it does not involve client security fund matter or a serious offense, and the court concludes that the violations, so a violation has occurred, but it was not intentional or occurred under mitigating circumstances and no significant harm resulted.
Got it. Okay.
So they did it, but they didn't mean to do it, and nothing really bad happened, is the way I read it.
Well, I don't think we have anything that does that the hearing officer can do.
Well, they could issue a public reproval.
Well, that's public. This isn't.
Yeah, but then that NDC, I was gonna say, I mean, there might be a place for it, but it just doesn't make any sense to me that it's not public. I mean, otherwise there's like no outcome to the viewer of that NDC. I guess they would then call the board or the SPAR and say like, what happened with this? And then you would turn the admonishment over to them, I guess, right?
I don't know.
Right. It has like no teeth to it whatsoever.
But you could have, if you wanted to do this, you could have a system where the NDC, a corresponding NDC gets taken down.
Yeah. If the hearing officer thinks that, I think I like this, because if the hearing officer thinks that this is there's a violation and it's so trivial that this is what is appropriate, it seems to me it's a useful tool. Even though I understand the idea that discipline should be public or violations should be public if it's determined to be a violation. Even so, you can see there could be exceptions to that.
Okay, Julie or Sharon?
I'm sorry, I wasn't able to attend the last meeting, so I'm just catching up.
Mm-hmm.
Was there a reason we decided for private for it to be NA?
Yeah, maybe Julie or Kim, you want to speak to that?
I forget, Sharon.
Me too.
I think we were looking at it from the perspective of if it is something that is discipline. It should be public.
Yeah.
And it's an action that's taken. And so from the public perspective, it should be out there. So we were saying there's a public reproval where individuals know that this individual did something that, you know, was a violation and it's posted. I think that's kind of where we were coming from. At least that's where I was coming from, was if you're going to issue someone something, especially if it's after an NDC, it should be something that the public is aware of. It shouldn't be private.
Yeah, and I would definitely agree with that. I would want consumers to be able to look that up and make up their own minds whether to hire this paraprofessional that may have a public reproval. I guess the question right now is for something that's non-serious and it didn't cause any harm and it was not intentional, whether this type of letter would be helpful.
I think what's interesting is we've created multiple like pathways out of the system at the OCTC level, because there's the warning letter, citation and fine. I think we were thinking about happening at the OCTC level as well. I'm wondering if for citation and fine, you want to make those possible outcomes at the hearing level. Now, the issue is because that might give the hearing panel more options besides just dismissal or public discipline, because the citation and fine is not considered discipline, but the citation and fine is public, albeit for a limited period of time. Whereas the admonishment, at least in the current, paradigm, is private.
And the reproval is discipline, right?
Yes.
So that's the difference really between it and the admonishment.
When we were talking about private reprovals at the last meeting, I wrote down, it is discipline, but it does not affect the license.
Yeah.
And it's not posted unless it is issued subsequent to the filing of a notice to show notice of disciplinary charges.
Right. Those were the public privates.
Right.
I guess I go with what Ira said. It's different. The only difference between an admonishment and the public or private reproval is that it's not discipline, right? That's really the only, is that different?
And the private reproval. Yeah.
The public reproval is considered discipline?
No. Both reprovals are discipline, but the public reproval is obviously public. The admonishment is private. So it's more akin to a private reproval.
I would love to know, kind of like going back to Sharon's, I'd love to know what is an example of this, where is this used?
Okay. Well, it might be that we need to leave this one as an TBD, and then I can get from State Bar Court some examples or what their views. My impression from the little conversation I've had about this so far is that it's disfavored by OCTC and favored by State Bar Court. I don't mean favored, but I think it is a remedy that is appreciated, and I'm not so sure I get the same feeling from OCTC. So maybe we can get a little bit better understanding.
I mean, I could understand that from my, time at the boards and bureaus, the boards saying, there's this thing that goes all the way up, you file an accusation, and when it all boils down, whatever comes out in mitigation, it wasn't willful, it wasn't intentional, but there's still a violation. What do you do with that? Although I've seen some ALJs actually issue a dismissal on those where they've said it just didn't quite rise to the level, but I guess that's why they like it, because they don't want to give the individual anything significant based on the facts, but there was a violation.
Yeah, it seems to me like it's some measure to like wag their fingers at the person and be like, hey, don't do it again. But I guess my question is, what is the difference between that admonishment and a warning letter, they seem to be the same in effect.
But one is not issued by the court.
Ah,
The warning letter is issued by OCTC.
Yeah.
by
Yeah.
OCTC. Got it. Okay.
Can
Can
I
I,
think the oh, sorry.
yeah, I'm getting all confused here. Can the court issue a public approval after the filing, in response to the filing of an NDC?
Yeah.
So that's one of the court's options. It could be a public approval, it could be probation suspended, it could be suspension, it could be revocation, disbarment,
Dismissal.
or dismissal, yeah.
And I think we should make sure the court could also do citation and fine, not just OCTC.
Yeah.
If
Because
the
it's
court,
not discipline. It would have to, maybe that's too tough, not the court, I'm talking about the panel. But if the panel is only doing things that are discipline, then that wouldn't work.
unless you have a disciplinary citation, and I've seen that in other states.
What's that, Kim?
So there's other states where we would get like out-of-state discipline on our licensees, where they would literally issue a citation and kind of to Sharon's point, a slap on the wrist or something with a citation or a fine attached to it, like a citation and fine, but it was considered discipline. It came out of a disciplinary action. Other states do that.
So other states issue a citation and fine, and that information comes to a California agency, and that is grounds for discipline or something at the California agency.
Right. So I guess that'd be the difference, Leah, is if it was, just before it went to an NDC and then after it went to an NDC, then it would be part of a disciplinary action.
So that's an option. Let me go to the other issue and then let's see what you guys want to do. The other issue was around this probation suspensions. I have determined that these are actually two distinct categories. Not everybody on probation is everybody who's suspended is on probation, but everybody who's on probation is not suspended.
Right.
So I think what we did should be sufficient. Since I think there was a question if we needed both of these, but them listed out separately, but I think we do.
Oh, that's the issue that we left on this?
I think that, yes, that's what my notes say.
Okay.
I think that one's fairly simple. And that was it that I had from my notes in this admonishment.
Did we have a discussion last time about people who are put on probation after an NDC? Does that remain on the website indefinitely or simply as long as the probation lasts?
The fact that they've been on probation remains on the website.
Okay, and I think that's the way it is at the Med Board at least, right, Kim?
Yeah, it's indefinite now for probation.
Right, okay.
The one thing we haven't talked about, Lee, I was thinking about this for our meeting today, and I don't know if it's something we want to tackle, but I don't know what the attorneys do right now for like convictions or like either a misdemeanor or a felony. Do those get posted on their record? And then the other thing I was thinking of is, what about an individual that applies for a license? Do you do like a probationary license, or they get issued a license that's on probation? And if you do, is that considered discipline? Because we don't consider those discipline. And so they actually have a different time frame of posting than probation that comes after your license.
For your last question, we don't have a probationary license.
You don't. So what if you have somebody that applies to you and they have some criminal conviction where it shouldn't kick them out, maybe potentially you want to license them, but you want to monitor them? What do you do with those individuals?
I'm not sure what you mean. So they're applying like from another state to be admitted to the state bar. If they're applying like through the moral character process, they're not yet attorneys, that issue would be resolved. Meaning we wouldn't let them, there's no conditional admission, there's no like letting you in and we'll monitor what happens with this situation. We don't have that. If you're already in, and then we get notice of a conviction, and maybe I hope that Linda has a better grasp on that than I do. I think she does. She's nodding her head. Then there are things that we do, but we don't kind of let people in while issues are pending.
So it's not pending. Let's say I'm 25 and I don't know, I steal something, and what's the different levels? I don't even know this. I should know this, but like it's a higher level of stealing than petty theft, or maybe it is petty theft or something like that. That is something for my moral character. And I go to law school, and now I'm applying to the state bar for a license, and they see that in this person's background. Would you just issue that person a license, or do you either just, I guess my question is, does the state bar just issue or deny? There's no middle ground.
There's no middle ground, but
Okay.
There's a moral character review process that would look into that, and based on the level of conviction, there's all different kinds of steps. So there's multiple possibilities for people, even with serious convictions, to be licensed, but at the end of the day, you're either admitted or you're not.
Interesting. Okay.
Do you want to explain, Linda, about the conviction, the flagging on the profile?
Yeah, so a conviction doesn't, just in and of itself, criminal conviction doesn't show up on an attorney's profile. But if an attorney is convicted of a crime and the state bar receives notice that the attorney is convicted of a crime, then our Office of Chief Trial Counsel transmits the conviction information to the state bar court, which then determines what action should be taken.
But there are also situations where we receive notice, even for some crime types, even where an attorney has been charged but not convicted. If it's very serious, we do flag that on the profile. So there are rules around this. There's like these big red box. I know we did it like with Avenatti. There is a big red box on top, very limited circumstances, and I think it's at OCTC's discretion where we're notified of charges. So
especially surrounding theft and embezzlement, and theft from a client trust funds. And there are rules, and there is a big red box on the attorney's profile that says consumer alert.
Yeah, yes, that's what it's called, the consumer alert rules. So those were revised not too long ago, and we can certainly get those to you, and we could just say we want to mirror that process.
Why does the bar not post criminal conviction, especially, I mean, we went through this at the Med Board. Felony convictions at the Med Board are now posted indefinitely by law. Misdemeanor criminal convictions are posted if they are the basis of an accusation, or NDC in your parlance. Why does the bar not post those? Or maybe you've never had the discussion.
No, there was a very robust discussion about this because of, there's a lot of tension. I've mentioned this before, between like the whole criminal justice world and the idea that you don't want to be tarred and feathered forever for something that you did, versus the consumer protection kind of framework. So consumer alerts, I'm looking on the State Bar website. This was the proposal. So I cannot find the actual rules, but this is what went out for public comment. Felony charges pending in a court. So all pending felony charges. Superior Court assumption of jurisdiction over a caseload. And I can look up what actually happened, but I do think we post felony charges, but interesting, not felony convictions.
So that's so interesting. It's total opposite of us. We don't post charges, but we post convictions.
We post felony charges?
No.
State
I
bar,
don't think that we do.
state bar is required by law to disclose to any member of the public so inquiring any information reasonably available. So we're required to disclose it if we have it. The charge information. I'm just reading straight from the website. I mean, any of us can do it. I think this sounds like something, because we don't need to kind of research it all together, is figure out exactly what the current status is on consumer alerts. And, you know, we can share that. My thought and suggestion is that we would align whatever we do for paraprofessionals with the attorneys, because this was a very complicated process, and to get the triggers correct to automate these flags was quite challenging. So at least initially, I think it would make sense to align with what is being done for attorneys. And I'm sorry, we can't tell you right now.
You said that if the bar received notice that an attorney has been convicted of a crime, that doesn't show up on the attorney's profile, but it gets transmitted to the Supreme Court. What are the Supreme Court's options then? Like
It's the state bar court. And I'm reading now from the 2019 annual discipline report. It says, following the receipt of information on convictions, OCTC attorneys obtain certified records from trial and appellate courts before filing these cases with the state bar court. Within 30 days of receipt of the certified record, OCTC is required to transmit the record of conviction to the state bar court's review department. If the case does not meet the criteria for summary disbarment, the review department refers the matter to the hearing department to allow the attorney an opportunity for a hearing. So they get filed, they get transmitted to the review department, not the hearing department. And they actually, it's kind of backwards. They get kicked down to the hearing department if there's not a criteria for summary disbarment.
If they get kicked down to the hearing department, is an NDC filed?
No, there's not an NDC.
Gee.
But OCTC does work up the case to provide information. They do have to do an investigation.
And that could result in an NDC?
I don't think an NDC is filed in these cases. I think it just it's based on the conviction.
Oh.
So interesting, so different.
Right. They just it's the transmittal of the conviction record.
Huh.
And then, well, what happens after that? After the investigation?
Well, so what happens is the case is heard in the hearing department, and then the court decides what discipline to impose. But some cases automatically result in disbarment, and that's where if the review department looks at it, and if the case just on its face requires summary disbarment, then there's not even a hearing.
I see. And there's an appeal from that determination?
Well, except that's done at the review department. I would imagine that appeal would have to then be at the Supreme Court level.
Yeah.
So I guess our position might be that we want this aspect of public disclosure for paraprofessionals to mirror what is done for attorneys, at least at this point. I would, including the consumer alerts issue, which I think Leah said she's going to do a little more research on. I don't know, I'm probably opening a big can of worms here, but I would argue for posting of criminal convictions because I think consumers have a right to know that.
I'm struggling with that too, because charges are public, yet convictions are not. That does not make so much sense.
Yeah, it doesn't.
And I'm all for giving someone a second chance and, clean slate and all of that, but I just don't know why charges are public and convictions are not.
Well, disciplinary charges are public, not criminal charges.
No, Linda, in some circumstances, OCTC
Oh, right.
can make some felony charges.
That's true,
Right.
but not in every case, right?
And I mean, to the giving people a second chance, maybe that's why you do just felony convictions out there as public and definitely. I mean, I think that's an important one. It takes a bit to get a felony.
Yeah, and I do think it's a consumer's right to know.
And it's hard to find it outside of, unless there's some press around it, it's hard to go through sometimes the criminal court system when you're, searching for somebody.
I have to
'Cause
say
it's by
though, that
county.
makes me, I think there's problems with doing anything on this subject that's different from what is done for lawyers because of the back and forth, the tension that Leah described that went into all this. In other words, the tension between the discipline system and the criminal court system. And I can see we can all see the criminal court's reasons for their position. I just don't think we ought to be changing it because it was apparently a very delicate balance. Seems like it must have been.
I just see a felony criminal conviction as being obviously postable because the burden of proof is higher in criminal court than it is in state bar court proceedings. And the attorney, if they don't, the respondent or the defendant, if they can't afford an attorney, they get one appointed for them, whereas that doesn't happen in state bar court. There's just a lot of due process protections for criminal defendants that don't apply in state bar court. And if a conviction occurs, that's very serious, especially a felony. When the medical board's statute was first enacted, felony convictions were designated as clearly postable. And in fact, they were one of 2 or 3 categories of postable indefinitely, like forever. We had to later fight about misdemeanor criminal convictions. And what ended up getting codified was misdemeanor criminal convictions that become the basis of an accusation, meaning they're substantially related to the duties and functions and qualifications of a physician. So that's where we ended up on misdemeanor criminal convictions. And those are posted now, right, Kim?
Yeah, if it's part of an accusation that results in discipline, it's as part of the accusation, and then if it results in discipline, if that accusation gets dismissed, it comes off, but otherwise it would stay on. Yeah.
Okay. I think what we need to do, it sounds like one approach on consumer alerts would be, as Ira said, to just align it with whatever is going on for attorneys for right now, indicating that it is an area for future, exploration. Another is to put it TBD, like we're going to do with admonitions. I'm thinking just simply in terms of what goes forward on the 26th to the full working group meeting, because it sounds like I'm even having trouble pulling up the minutes from the relevant board meetings where the consumer alert issue, this is in 2018 and 2019, was, addressed, this whole host of modifications. So we can do more work on it and put it as a TBD. Either way, however you guys want to go.
That sounds fine. to me.
Okay.
Me too. I think it's hard to change from what you're doing in the attorney side.
Yeah.
But so but I'm putting as a TBD, suggesting we might change it, but let's not first provide you with a better clarity around what the current status quo is.
Yeah, I think that would be helpful on this particular issue. It wouldn't hurt to have a more robust conversation with a full working group on this issue.
Okay. All right, then perhaps what we can do is I can make sure to get more information and then tee it up for discussion on the 26th.
Leah, I was under the impression that those consumer alerts first came about back in like 2008, 9, 10, when we had the mortgage crisis and the predatory loan crisis, and there was a bunch of urgency legislation passed prohibiting lawyers from taking, oh gosh, I'm not remembering it now, but I think consumer alerts are older than 2018, 19.
No, right, but this is when the interim chief trial counsel at the time, or the requested a host of changes. This most a huge package of reforms is in November 2018. They had already been in effect, but I'm trying to find the minutes to find out exactly what happened, because there were a lot of things that were asked for.
Okay.
So, yeah. OCTC wanted a number of things to be made public and posted, but I'm not finding the minutes so that I can confirm what actually happened.
Okay.
Okay. So I think those are our last two items.
Amazing.
I know. Great job, guys. I will get you a draft of your memo early next week, and it will have information in it, more information on the consumer alerts piece. And we'll work through our process to get that finalized and posted for the meeting. Okay.
That's good.
Okay.
Yeah.
All right. Thanks.
Good
everyone.
conversation today.
Yeah. Great work. You guys are a very hard-working working group all together. A real working group. Yeah. Okay. Have a good holiday weekend, everyone.
You
Oh,
too.
too.
Thanks.
Bye.